Good evening to everybody. Welcome to the class, and this is the 9th class which is going on there. And yesterday that I made the class at the 5:10 to 6 o'clock, but I found the meager strength would be there. It gives a sense to me that 7:10 to 8 o'clock is very much feasible to you and convenient to you. Yes, read what I posted on the screen. Anyone can unmute and read. Hurry up.
There are 4 different types of abbreviations in English. Initialism, CBI, the Central Bureau of Investigation. Acronym, ICRISAT, International Crops Research Institute for the Semi-Arid Tropics. Shortening, February. Contraction, I will, I apostrophe LL, I shall or will.
Is it the same thing which I posted in the morning? Anyone? Is it the same thing which I posted in the morning?
I don't have any idea, sir.
But I posted it in the morning to everybody. Not because there is a different way. The initialism there is put not CBI, FBI. And in the ICRISAT is the same. But the shortening, I did not put the February, I put the August. In the contraction, it's I will is there, but there only I will is there, I shall is not there. I shall, virgule, will is there. So that is the difference between the morning and the evening one. Again, I will show you over here. See, this is FBI is there, August is there, I will is there. Yes. Now you tell me what is these are. Here some examples of the abbreviations are there. Now you tell me. MP? Tell me.
Member of Parliament.
Yes, I know it. In the 4 categories, what it is?
Initialism.
Initialism. I appreciate. సార్ మాకు తెలుసు సార్ ఇప్పుడు నాట్ అంటే తెలుసు సార్ ఎందుకంటే సీక్వెన్స్లో అడుగుతాను కదా సార్ మీరు I put it in the sequence. I should not supposed to put it in the sequence. That's why that you know it. NATO. NATO.
Acronym, sir.
Acronyms.
Good. And I know the DAPP full stop generally would come over there. That is the shortening. And DR full stop also there. That is comes contraction. Generally, the contraction, one difference is there. In the contraction, there is a apostrophe is there. And that is only the difference that we'll find it. But here say it's a contraction. No, it is a shortening only. It is a shortening only. They would is a contraction. Are you following me?
Yes, sir.
Yes, sir.
The apostrophe is there. They would, it is a contraction. So the purpose of my showing this is read, recite, review. That means if you do it now, you will not forget it. That is my intention. Now let us, without wasting the time, we will go. We are discussing in the last class Kasturi Lal case law. And this Kasturi Lal, I told you that he is a man, a goldsmith, jeweler, and the Malkhana, they put it, the gold, and some of the gold was stolen away from there. And the policeman has fled to the Pakistan by taking out the gold. They said it is a Malkhana is a sovereign function. In the sovereign function, if a person is doing over there, then the sovereign will not be held liable. That means state is not held liable. That was the judgment given over there. But later on the cases, all this judgment is bypassed, and they say state is held liable to pay the compensation. Because it is the state who could not protect it, then who will protect it? That is the reason that I put it over there. Then it comes to the matter of the UOI. Can you write the UOI in this way? Can you write the UOI in this way?
No, sir. Union of India.
Actually, when you Union of India written, no, actually it is the O should be a small letter, but here some people what they do, no, they will keep the capital letters. No? But anyway, better don't write like this. Better you write Union of India. Sometimes you can put, but you cannot keep the full stop over here if you want to keep. Then UAI is the initials, because initial doesn't have the punctuation, and this V should be the, of course, everything should be the italics. Italics. The Union of India versus Sograbai. This is the case law. A military driver of the School of the Artillery once assigned a task to transport the machine and hit B. As a result, B is a passerby there, and B, as a result, B died on the spot. And here the government is liable as the work is assigned to him at the act committed during the discharge of his duty. So whenever the goods are transported from one place to another place, and the state are not supposed to say it's a sovereign function, because that function can be done by the individual also. Hence, it is not a sovereign activity, it is only an individual activity. So how an individual would be held liable? In the same manner, the state is held liable. Either state is a central state, I mean the central government, or the state government, or even the municipality also. So these are the things would be there under the government liability. And I already told you the government liability, the government is held liable. A government can sue, a government can be sued. So what is that case law again? Repeat. Where that I use the government, state government, Jammu and Kashmir. What is the case law name?
Bhimlal was Jammu and Kashmir.
Bhim Singh versus state of Jammu and
Uh, uh,
Kashmir.
They did not allow into him parliament.
Not parliament, assembly.
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 See, there is no other equation rather than the repeating. Read, recite, review. These are only the secret of your success. సార్ ఎన్ని గుర్తుపెట్టుకోవాలా సార్ కేస్ లాస్ ఇప్పుడే చెప్పాను నేను, ఎందుకంటే మీరు గుండె వెలుగుతారు ఇప్పుడు చెప్తే. So I don't want to say now, sooner or later that you will learn it, because you also say that, sir, it is very easy to remember the cases. See, we are also developed the technique to remember the cases. Yes, because we are our own style. Yes, you can do the own style because there is no hard and fast rule. Yeah, now let us go to the foreign sovereign. A foreign sovereign cannot be sued unless they themselves submit to the jurisdiction to the local government. Of course, as foreign sovereign, we cannot sue it like we cannot sue the ambassador of the different country, because when you want to sue, first we have to take the consent or the permission from the respective government. So by residing in a foreign country, one does not waive his right to jurisdiction from the local government. Of course, there is a civil procedure code also says a foreign sovereign can be sued in India only with the consent of the central government. The condition of with the central government gives the permission. Yes, if the foreign sovereign has instituted a suit in the court against the applicant, if the foreign sovereign by himself be the or by agent or trade with the local limits of the Indian court. Yes, if the foreign sovereign immovable property in respect of which the applicant was to sue is situated in India, yes, section 86, as per the provision of these sections. See, when I write the sections, I used what I used when I use the sections. Double S I made it, but the first S is a capital S. But when you're writing the PP, we don't write like that. Small p, full stop. That is the only difference you will find. But here, when you say the sections, yes, they have written it. 86 to 87, is it the right way to write? 86 to 87, is it the right way to write? Yes or no?
No, sir, because 86 and 87 comes after 86, so you don't need to write.
No, you have to write.
No, sir. 86 and symbol, sir.
And should have to write. I appreciate. And should have to write. This is the style of writing. Don't write 86 to 87. You write 86 and 88. Sometimes you put the symbol, but try to avoid the symbols. You put the and only. It's a better way. So this is the style of writing, CPC. Now CPC is a acronym, abbreviation, or contraction, or initialization. Yes.
Initialism.
Initialism it is, because CPC, we are reading the each and individual word. We are not saying NATO, OPEC, Cafe Posa, Ikrisat, POXO. We are not saying. So that's why it is there, initialism. Yeah. Now, a suit against a foreign sovereign without the consent of the central government is only permissible where the plaintiff is a tenant under the foreign sovereign. And the suit really relates to the land held by him. Of course, in the foreign places, when you as a tenant is there, yes, you can sue at the time, but is a personal action but is not amount to any other action. Hence, you need not to take the government permission. They said when you are staying in the foreign government. Suppose if you are staying in the foreign government there, I can sue or I can be sued over there because nobody would have to break my fundamental rights, or without my consent, nobody should have to touch me. Either I am in India or in the foreign country. Am I right? Am I right?
Yes, sir.
Yes, sir.
Otherwise, the permission of the central government is mandatory. When the permission has been applied for and refused the permission, it is not open to the court to question of the property of the order of the refusing consent. But now a mere notice is enough. I think 1 month or 3 month notice should be given to the government. If they could not give the reply, yes, directly you can file a suit against the government also. Yes. The illustration, A wants to sue B, a foreign sovereign, he can sue only by taking the permission of the central government, because if a foreigner would be there. Suppose if you are staying in the foreign country and you are having the residence permit, at the time you can sue it in the foreigner, in the foreign country. So ambassadors, a foreign ambassadors, sir, ambassadors antaru, sir, diplomats antaru, sir, high commissioner antaru. Enti sir ivanni? There is a slight difference would be there. In some countries, the nomenclature is high commissioner. For instance, you take the East African countries, there we can say high commissioner, we don't say ambassador. And when you say the France and other places, we'll say the ambassador. But in other places, we'll say the diplomat, depending upon the country and the nomenclature. I believe there is a responsibility also there, I believe. That is another point would be there. Sir, difference ఉన్నదాలే సార్, టీచర్ అంటాం మనం, లెక్చరర్ అంటాం, మరి ప్రొఫెసర్ అంటాం, మరి ప్రొఫెసర్ ఎమిరేటస్ అంటాం. ఏంటి సార్ ఇది? ఎస్ సార్.
According to the levels, these are the levels of
Education. Levels of education.
Teaching. Levels of the teaching the person in the different places. Sir, teacher కన్నా తక్కువ చెప్పండి సార్.
trainer or mentor.
Oh, you can say tutor.
Yes.
Because the nomenclature is different. Here we'll say assistant professor and associate professor and professor in the university level. But where I worked there in the University of Dar es Salaam, no, first is the assistant lecturer, below is assistant tutor and tutor, then assistant lecturer, then senior lecturer, then associate professor, then a professor of law. So that is the nomenclature would be there. Okay, let us see the one of the Harbhajan Singh Dhalla versus Union of India. The petitioner in this case carried out the building maintenance, reconditioning and renovation of the Algerian embassy. It is an embassy of the Algeria and the residence of the Algerian ambassador. See, Algerian ambassador they say, Algerian diplomat we did not say, and Algerian high commissioner we did not say. But if you go to the Tanzania, there we will say not, they say Tanzanian high commissioner they will say. All the diplomats are there in the Delhi. Generally, all at one place only. But a Tanzania, a little difference inside that you have to go it. But there you will say the High Commissioner of Tanzania. So here the ambassador in New Delhi, he tried to collect his dues but failed, then requested the Ministry of External Affairs to grant a permission to sue the Algerian embassy. The ministry refused to grant the permission on the political ground and also continued that under Section 86 of the petitioner failed to make the prima facie case, and if a permission has been applied for and refused by the government, it is not open to the court to question the propriety of the order refusing the consent. But in certain cases, the government will not refuse it. Even the government will pay it because the reputation of a nation. See, when the ambassador comes to your place, you try to protect him. But you cannot protect the ambassador if he is committed in the murder. Are you following me?
Yes, sir.
Yeah, because sometimes you have to take the permission. If the permission has been applied and refused by the government, it is not open to the court to question the propriety of the order of the refusal of the consent. Then we cannot question the consent because it is a question of reputation of a country. That is also them. And if you have to try to respect it, after all, it is the money you can get it, no matter. Okay. So now let us see the public officials. No action lies against the public officials in their official capacity with respect to charges committed with them. Suppose if a judicial magistrate will sentence you for the either 3 months or 1 year, 6 months or whatever it may be under jurisdiction, can you file a case against him? Yes? Can you file a case against the judicial magistrate?
Can you repeat the question, sir?
No, sir.
You cannot file a case against the judicial magistrate, suppose if he has delivered the judgment for the punishment to you. Because Judicial Protection Act is there, that would be applicable to them. Even a judicial magistrate also can say in the arguments or in the cross-examination, chief examination, re-examination, they say, I think that you are a liar. He can say, because he observed the two contradictory statements. So he cannot, I doubt you are a liar. I cannot have the faith on your statement. He can say, nobody will challenge him. Suppose if you are not happy by his decision, go to the appeal. Are you following me? Say yes.
Yes, sir.
Yes, again,
Yes,
here, Union of India versus Bhagwati Prasad. In this case, the train collides with the taxi. So there is a collision between what? Collision between what?
Train and
Train
taxi.
and taxi.
Yes. Do you expect the collision between a plane and a bicycle?
No.
No.
First, bicycles are not allowed on the airport, even on the runway also. So, for these, Bhagwati Prasad files a case against the Union of India for negligence. It was held that the suit for the damages can be filed against the act of the officials in their private capacity, but not for the act done under the sovereign power. Suppose accident అయింది అనుకుందాం, ట్రైన్ కొలిజన్, ఎవరు తప్పండి?
Taxi.
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 Why taxi? Why not the train?
Because train will not move on the road.
Not enter the train route, sir.
The train is always laid down and the train coming sounds will come out. How many level crossings are there, sir? Level crossing ఎట్లుంటాయి? 2 ఉంటాయి. ఏంటి లెవెల్ క్రాసింగ్ చెప్పండి?
అండర్ క్రాసింగ్,
చెప్పండి.
ఓవర్ బ్రిడ్జ్.
అది ఫ్లైఓవర్లు ఉంటాయి అనుకోండి, ఓవర్ బ్రిడ్జ్ ఉంటాయి అవి. When I say the level crossings of the train and the taxi, the road is there. Number 1, manned level crossing. అంటే మనిషి ఉంటాడు అక్కడ గేట్ అయ్యేదానికి. Number 1. Number 2, unmanned level crossing. ఈ unmanned level crossing la whose burden one should have to take the care?
Self, sir.
The person who wants to cross the railway track should have take the more care. కాకపోతే అటు ఇటు సైన్ బోర్డ్ పెడతారు. ఏ సైన్ బోర్డ్ మీద ఏ రాసి, వాట్ ఈస్ ద రిటర్న్ ఆన్ ద సైన్ బోర్డ్? కాషన్ బోర్డ్. Look and pass, or
Pass.
stop and pass, or train, observe train then pass, or danger, pass with care. Anything, something should be there. Or a train image is there and they say stop. Means when the train is coming, you stop. But some places no, when the train comes, of course now mostly the level crossing are automatic, they made it. From the distance they can put the gate, or from the distance they can give the signal also. Yes, the red light will come over there. From the distance they can maintain it. Red light, the beeping would be there and beeping sound also comes over there. And moreover, a person who wants to cross the level crossing, where is the unmanned level crossing, he will look at both the sides, then he will pass it. But some people know they want to go early. They, even though the gate is there, but from the under the gate they will pass on. When you under the gate you pass on means you are not going to get anything, because voluntarily that you are crossing the limits. So that is the reason, if any collision between there, it is you have to take the care. It is not the central government, other railway department. Now let us see the infants vergule minor. Infants vergule
Vergule
minor.
minor.
Yes. Anyone wants to speak? Vijayalakshmi, you would like to speak? because I could see the speaking sound there. Shall I proceed? Say yes.
Yes, sir.
Very good. Infants and minors, the infant's minor can be sued for the act committed by them as an adult. Thus, a minor can be sued for the assault, false imprisonment, libel, slander, fraud, but where intention or knowledge or some other conditions of the mind are essential ingredients of the liability, then in the case, a minor or infant can be exempted due to their mental incapacity. Where there is intentional act would be there, where the minor doesn't have the mental incapacity at the time the minor is not held liable. But generally, a minor which is below the age of the 7 years, he could not commit an offense. 7 to 12 years mental maturity. 12 to the 14 years or 18 years, they will take the old RI test. Some test is there. They will apply it. They will say that whether we can consider the minor evidence as a relevant or not, whether the minor could do such an activity or not. So they will check it, mental maturity, when they are committed it. Suppose when the minor committed a tort, and they don't test the mental maturity, because the tort, the compensation should be paid over there, and hence even the minor's activity, the father is held liable because of the vicarious liability, because a minor would be identified by his father. So two little boys were playing cowboy related games, and one boy hit that arrow and it hit the another boy in his eye. The court gives the judgment in the defendant's favor, as 5 years old does not even think about it, hence the defendant is not liable. Suppose both are by playing the arrow game. Sir, arrow ఎక్కడ ఉపయోగిస్తారు సార్? Yes? Where do you use
Archery.
arrow? Yes?
Shoot
Archery, sir. Archery.
ఆర్చరీలో యూజ్ చేస్తారు. ఆరో ఎట్లకెళ్ళి గట్ల పెడితే కొడతారా అండి ఆరో? సార్ అయాన్ ఫ్లెమింగ్ సినిమాలో చూసిన సార్, వాడు గల్ల పెట్టిండు సార్ ఆరో, ఆ కొడితే దగ్గర పోయి అక్కడ పోయి పడ్డది సార్, అది గుడ్డ చుట్టుకున్నది, దెన్ హీ పాస్ ఫ్రమ్ దేర్ హియర్. సో దట్ ఆరో ఈస్ డిఫరెంట్, బట్ హియర్ ద ఆరో విల్ బి పాస్ త్రూ ద
Bow.
బౌ.
Bow.
మరి ఇప్పుడు చెప్పండి సార్, నేను 100 రూపాయలు ఇస్తా మీకు, ఏది గూగుల్ పే కొడతా. ఆరో పెట్టడానికి ఏమంటారు అంబుల 10ని ఇంగ్లీష్లో చెప్పాలి. ఆరో పెట్టే కంటైనర్ ఏమంటారు? వెనక ఉంటుంది, అమ్ముతట్టు ఉంటుంది ఆ కంటైనర్.
bow and arrow.
Sir, sir.
Professor Hussain students only can tell such a thing, sir. No other man can tell it. QR ఏంటిది? అంబుల 10 తెలుగులో ఏమంటారండి?
అంబుల 10.
I think I am right in the spelling, I am right in the everything. QR చూసారా అండి స్పెల్లింగ్?
Yes, sir.
QUIVER.
Sir, in Telugu it is called అంబుల 10.
స్పెల్లింగ్
QUIVER.
QUIVER.
సో am I right or wrong? సార్ ఏదో
Yes, sir.
కొడుతుంటారు నాయన, కొట్టుడు కాదు. I will challenge it, I will prove it. Of course, I may be a man, errare est hominum. I also commit a mistake, but I try to see that I don't commit the mistake as far as possible. So you keep the container of the arrow is a QUIVER, QUIVER. ఇక సార్ ఇక ఇప్పుడు అడుగుతా సార్ మా పిల్లల్ని, ప్లీజ్ డోంట్ డూ ద ఎక్స్పెరిమెంట్. పాపం వాళ్ళని చంపకండి, బికాజ్ వాళ్ళ ఇంగ్లీష్ టీచర్ చంపుతారు. మీకు ఎవరు చెప్తానరా ఇవన్నీ? మీరు సార్ టాడ్ చెప్తాడా, ఇంగ్లీష్ చెప్తాడా, మ్యాథమెటిక్స్ చెప్తాడా, మొత్తం చెప్తాడా? సార్ ఆల్రౌండర్ అన్ని చెప్తాడు అని చెప్పండి తర్వాత. ఓకే ఓకే. ద కోర్ట్ గివ్స్ ద జడ్జ్మెంట్ ఇన్ ద డిఫెండెంట్స్ ఫేవర్ యాజ్ 5 years old డస్ నాట్. ఈ డస్ నాట్ ఏంటిదండి? ఇది ఇక్కడ కాంట్రాక్షనా, ఇనిషియేషనా, ఇది షార్టనింగా?
Contraction, sir.
Shortening, sir.
షార్టనింగ్.
sir.
అపాస్ట్రఫీ వచ్చిందంటే నెవర్ రైట్ ఇన్ యువర్ ఆర్టికల్, నెవర్ రైట్ ఇన్ యువర్ రిపోర్ట్, నెవర్ రైట్ ఇన్ యువర్ డిసర్టేషన్, నెవర్ రైట్ ఇన్ యువర్ థెసిస్ ద వే దట్ ఇట్ ఇస్ దేర్. You are supposed to write in this way. Even you think about it, hence the defendant is not liable. So defendant is not liable in the archery because it is one cannot think it out, and one cannot having such an attitude be there. దట్స్ వై దట్ నోబడి వుడ్ బి హెల్డ్ లయబుల్. ఒక కేసులా చెప్పినండి నేను మీకు. ఆ పేరు చెప్పగలుగుతారా అండి? నేమ్ ఆఫ్ ది కేసులో చెప్పగలుగుతారా, లేదా ఫ్యాక్ట్స్ ఆఫ్ ది కేసులో చెప్పగలుగుతారా? స్కేల్స్ ఉంటాయి, ఏది ప్లాస్టిక్ స్కేల్స్. ఫెన్సింగ్ చేస్తూ ఉంటారు ఇద్దరు అమ్మాయిలు. ద ద ద పీస్ ఇట్ వెంట్ టు ద ఐ అండ్ షీ వాజ్ డ్యామేజ్డ్ ఓవర్ దేర్. So
sir. Mullin versus Richard, sir.
I appreciate. నాకు తెలుసు 100 రూపాయలు పెట్టలేదు నేను, ఎందుకంటే నాకు తెలుసు
Sir.
సార్ మీరు టూ ఇంటెలిజెంట్ సార్. నాకు తెలుసండి ఎంత how much the water that you are there, I could easily make it out. Mullin versus Richard, in that case that we did fencing, FENCING, fencing. I have given the different meaning of the fencing. కట్గానే చెప్పండి సార్ ఫెన్సింగ్ లో. What the instrument is used in the fencing?
Stick, metal wire. EPEEP, a sambre, 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 or easy way, file, 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 file. So that is a very easy way to, don't say sword. Yes. Now here a woman was with the child was injured in a railway accident, and that child, when was born, found the deformed. The infant came to some amount as a damage from the railway company. It was held that the infant child cannot maintain an action because the infant, when with the womb, could not get any ticket, hence he is not going to get it. But now congenial defect act would be there, passed over there. But now that situation is changed. For instance, you take the Montreal tramways level. Sorry, tram అంటే చూసి తెలుసా అండి మీకు? ట్రామ్, ఎస్, do you know what is tram? TRAM, tram.
No, sir.
No,
Why you are taking so much time? Trams only you will see in India, in Calcutta. అది ఎలక్ట్రిక్ ట్రైన్, అది రోడ్ మీద
powered by
నడుస్తుంది.
electric.
అది రోడ్ మీద నడుస్తుంది. ట్రామ్ వచ్చినప్పుడు యూ షుడ్ బికమ్ ఎ సైడ్. It passes through the trams. The trams should be there like a local train. It is. So that is a tram level. Is the Supreme Court of Canada allowed an action by child born with the club feet 2 months after the injury to its mother by the negligence of the defendant. Majority of the writer in the favor of the view that the action for the prenatal injuries. Prenatal means before the delivery, or కడుపులో ఉన్న how much time that a fetus would in the mother's womb?
9 months.
9 months.
ఆ పీరియడ్ ని ఏమంటారండి? ఆ పీరియడ్ ని ఏమన్నారు?
Period.
ఎస్,
prenatal.
గెస్టేషన్ పీరియడ్ అంటారు దాన్ని. ఆర్ గెస్టేషన్, GESTATION. Gestation period is 9 months. That fetus. So it is, the fetus was injured over there by the negligence of somebody else, where the mother got the accident, and where the child is born, the club feet are deformed or mentally retarded. At the instance, the person who made such an accident would be held liable to pay the compensation. The law does not make any distinction of the basis of the age. Even a fetus is a person. That a child of 7 years would be sued for the trespass like a person of full age. However, if the authority such requires a special mental element, such as a disease, malicious prosecution, conspiracy, a child cannot be held liable for the same unless sufficient maturity or the committing the tort can be proved. In this case, that is the Walmsley versus Hamnick, the case law, the Supreme Court, British Columbia, held that the defendant, a child of the 5 years, how much the age of the child? A child of the 5 years could not be held liable for the negligence because he did not reach the stage of the mental development where it could be said that he should be found legally responsible for his negligent act. So the mental maturity will be taken into consideration, especially in the criminal law, but in tort law, they never consider it the mental maturity, because the tort law is only the compensation. If a boy has thrown a stone on the windscreen is broken over there. At that instance, the father of the boy should have to pay the compensation to the person who got the victim. Is it clear?
Yes, sir.
The liability of the parent for the Children's Act. As a general rule, the parent or a guardian cannot be made liable for the torts of a child. There are 2 exceptions to this rule. Number 1, when the child's father, servant or agent, father is vicariously liable. It may be noted here that in such a case, the father is liable for the son's start. Suppose the father is the employer and son is the driver. At that time, for a driver activity, the father is liable because of the vicarious liability would be there. And as a father, an employer. But in the capacity of an employer or a principal there. But when the father himself, by his own negligence, affords his child an opportunity to commit a tort, he is liable. Suppose can you keep a loaded gun in the reach of a child?
No, sir.
No.
Answer is no. The gun, a revolver, I was having, I don't know whether you checked it, a revolver or not. There is a one button is there, that is lock it. You can lock it, then the trigger will not move. Are you following me?
Yes, sir. Yes, sir.
Yeah, you check with your friend, anybody is having a revolver, like sub-inspectors or circle inspector, or a person who is having revolvers because he is having the license to keep the revolver. Of course, revolver is 12 rounds revolver is there, 7 rounds revolver is there, depends upon the cost of it and the license of it also. So, such a hazardous things or a dangerous thing should not be in the reach of a child. So, a BB versus sales, the father supplied an air gun to his son aged 15 years. ఎయిర్ గన్ అంటే చూసారు అందరూ, అందులో ఎయిర్తో నడుస్తుంది అది. సో దెర్ ఇస్ ఎ pellets is there, then you can air, then you plug it, automatically the gun shot will come and you can just kill the birds for the air gun. So that he allowed the air gun son aged 15 years, even after some complaints of a mischief caused by use of the gun, he allowed the gun to remain with the boy, and who therefore accidentally withhold the plaintiff, the father is held liable. పాపం ఆ ఎయిర్ గన్ రాగానే ఏం చేసిండు అబ్బా, తుపాకీ రాముడు తిరిగి ఏం చేసిండు, he want to shoot a person like a hide and seek, but it got the injury would be there. But it's such a hazardous thing or such a dangerous thing should not be reach of a child, and hence and this child is a mischievous child, and that everybody knows it. At that instance, the father is held liable to pay the compensation when the child committed such an offense to anybody. Now the lunatic, there are two conditions related to the lunatic. Number one, if the act was done by the lunatic when he is not in the condition of the stable mind, number one, the condition of the lunatic cannot be sued. So if the condition is not a stable mind, if he did the act, he could not be held liable. But when he is doing the act in the stable condition, at the time he would be held liable. Illustration, if A commits a battery against a B when he is not in a condition of stable mind, and he cannot be sued because the mental ability is not good. Sometimes that's why we cannot say that he could not be held liable. But if the act was done by the lunatic when he is in the condition of the stable mind, he can be sued. Yes, when the stable mind that he did an act, sir, I am not saying that did you admit in the Erragadda. No. I said, did you visited any time Erragadda to see the people, those who are there? Anyone?
No, sir.
Yes, sir.
సార్ అసలు ఎర్రగడ్డ అంటే చెప్పండి సార్, ఏంటి సార్ ఎర్రగడ్డ హైదరాబాద్లో?
Name
Sir,
of
it is a
place.
mental hospital.
Mental
Yes.
hospital.
There is a mentally retarded hospital is there in Erragadda, which is very far away to the roadside. At least you go at half kilometer or a kilometer inside. The inside it will be the patients who are there. If you look at the patient, and you will get very much surprised whether he is a mentally retarded fellow, because he speaks so good English with a grammar, and so nicely. But the people say that, how could that fellow would be admitted in the Erragadda? Of course, after meeting over there, just he was passing over there. Then from the behind, a big stone has made a good throw on his head, and he was bleeding. And this fellow saying that, please don't forget what I said. Means he is reminding the person with a stone and hitting him on the head. Can you say that? Then this fellow realized, oh, that is the reason this fellow is in Erragadda. I was thinking that his English is very good and he's speaking very nicely. I did not feel that he is having such an habit of it, because at the time he is very much stable mind. But when he is throwing the stone, he will be in the convulsions. Are you following me? Are you following me?
Sir,
Yes, sir.
సార్ మీరు మామూలుగా చెప్తేనే మేము అర్థం చేసుకోలేము కాదు సార్, మరి మీరు జోక్ చెప్తే ఎట్లా అర్థం చేసుకోవాలి సార్? మేము ముందుగా అర్థం కాదానికి మాకు టైం దొరుకుతుంది కాదు సార్, కనీసం ఒక హాఫ్ అన్ అవర్ ఇవ్వండి మీరు జోక్ చెప్పిన తర్వాత, సో దట్ వీ కుడ్ లాఫ్. ఆర్ యూ ఫాలోయింగ్ మీ? సే ఎస్.
Yes.
Yes, sir.
Okay. Illustration: if A has a disease where he becomes a lunatic for some period, but becomes a normal person after some time, and if he commits a battery against B when he's normal, in that situation he can be sued. But if he's not in normal, he cannot be sued. మూర్ఛ రోగం వస్తే చూసిండ్రా అండి మూర్ఛ మీరు
No.
Yes, sir.
Yes,
ఎపిలెప్సీ
sir.
అంటారా
ఫిట్స్ సార్
ఫిట్స్ వస్తే చూడండి దట్ ఫెలో
అవును
బికమ్స్
సార్
he will bite the his teeth, and you have to give some keys in the hands. Some people say you have to show the leather smell to that fellow, but after 5 minutes later that he will be quite good, and he will stand up and he will say nothing, as if nothing has happened to him. Are you following me?
Yes, sir.
ఎస్ సార్
Yes.
Yeah, because at the time he was in conversion, he doesn't know. So the people are very much, but they said we know it when we are getting it. So people say at the time, no, we know that we are going getting the conversion, so they don't travel it. They will sit down at the down. But when they travel, it comes now, it's dangerous. Are you following me?
Yes, sir.
Okay, now let us see the corporation cannot be sued. What is the role of the corporation? The act done was within the scope of the agent employed by the corporation. The act done was within the purpose of the incorporation. The Polton versus London Southwestern Railway Company, if the railway master was employed by the defendant company, arrested a man for the not paying the freight charges of the horse he is carrying with him. The petitioner filed a case against the corporation. It was held that the railway master was employed to arrest the person only if the person does not have the pay for the freight of the himself, not for the animals. In order that he was given to him the arrest person, if he is not paying the freight charges for the goods carried by him, and here he is acting in a private capacity, corporation cannot be held liable. The reason is there, they have given the right to the person. If any person doesn't have the ticket for himself, not for the freight, not for the horse. So this fellow is detained, that fellow, because he did not take the ticket for the horse, because horse is free, because he rides the horse again after going from the train. So sometimes it will be done. So if it is clearly written over there, then you should make it out. If it is not there, but now if you take any horse, can you take it in a compartment? Answer is no. Either you want to take a horse or any other thing, there will be a separate cargo is there, the compartment is there, the compartment they will take it out. Of course, you have to take the freight charges. You have to pay the charges for its luggage when you are carrying a particular thing. Are you following me?
Yes, sir.
Yes, sir.
But a small tricycle, if you are carrying with you, you can carry with your bogie. It doesn't matter. So now let us see the trade union. What is the, in India, under the Trade Union Act of 1926, a registered trade union cannot be sued. But the changes in Act 1939, now a trade union can be sued in its registered name. Yes. Now, if one of the member of the trade union named XYZ commits a tort, then in Section 1, as per the Trade Union Act 1926, XYZ cannot be sued because they have certain immunity. So situation 2, after the changes in 1939, XYZ can be sued. So now the present position is he can be sued. What about the married woman? So where the husband or where acting as an agent or a servant of some third party, again, now the present position is the married woman is like a woman, and one can sue him without the permission of her husband. Earlier, the husband's permission should be taken and we should sue. But now we can sue independently the married woman. Thus, where a husband, while driving a car as an agent of his mother, injured his wife, the wife sued her mother-in-law, then the husband has two capacities. One, the capacity of the vicarious liability, another in the capacity of the son. If the husband and number one are that of an agent of his mother, and in the above case he was considered to be acting in the capacity of an agent at the time of the accident, at the time the vicarious liability will come into the picture, and for the employee's activity, the employer would be held liable. One of the case law that we will observe is the Broom versus Morgan case law. Can anybody will unmute and read this case law? Read. Broom versus Morgan case law.
In Broom versus Morgan, it was held that if a husband committed a tort against his wife in the course of employment of his master, the master was liable for the same. Denning L.J. observed, if the servant is immune from an action at the suit of the injured party owing to some positive rule of law, nevertheless the master is not thereby absolved. The master's liability is his own liability and remains on him, notwithstanding the immunity of the servant.
Yes. Now the question comes over here. If the husband committed a tort against his wife in the course of the employment of his master, then the master is held liable. Because according to Lordin, Denning LJ observed, I quote, if the servant is immune from an action at the suit of the injured party owing to some positive rule of law, nevertheless, the master is not thereby absolved, only free from the liability. The master's liability is his own liability and remains on him, notwithstanding the immunity of the servant. I unquote. That is the way of study. So, in certain places, the immunity would be there because when the act is done in the course of the employment. If you say at that instance, for the employee's activity, the employer is liable. Don't worry, we do have the vicarious liability, a separate chapter would be there where we can show what are the relationship would be there. Number one, master and servant. Number two, employer and employee. Number three, agent, principal and agent. Number four, partner and other partners. The husband liability for the wife starts, of course. At common law, a wife committed a tort, there would be an action against both the husband and wife because wife could not be sued alone. A husband was liable for the tort of his wife committed after the marriage. Now, under the Married Women's Property Act 1882, a husband was also liable for the prenuptial torts of his wife to the extent of the property acquired through her. Even before the engagement, also, if he gets some property from through the wife, then he should have to pay from the compensation if any act done in the prenuptial time by the wife. The law reforms married women and tortfeasor within parenthesis Act 1935 has changed the position now. Husband is not liable for any tort of his wife. The present position is husband is not liable for any tort of his wife, whether committed by her before or after the marriage, merely because he is or her husband. If the husband and wife are joint tortfeasor, they can, however, be made liable jointly in each other. What is the present position is husband can sue the wife, a wife can sue the husband. So overall, a person who suffered the injury has the right to file a case against a person who caused this harm. Because I told you that maxim. What is the maxim? Where there is a right, there is a.
Where there is a right, there is a remedy.
What is that Latin terminology?
Ubi just remedium.
Remedium.
You be just,
Be
EB
just, be
remedium.
remedium.
You be just, EB remedium. That is the way of to remember the things. So, an injured person has a right to bring a lawsuit against the person who caused him harm, but there are some types of the persons who are unable to sue a person for their loss, and there are also some individuals who are unable to sue an entity such as foreign ambassadors, public officials, children, sovereign, alien enemies, but there are some restrictions are there because of someone who is of sound mind are not excluded by the statute, but is of unsound mind when he was doing an act, yes, he will be excluded from the statute. So, in determining whether the lawsuit stands before the court of law or not, the right to sue and be sued is very significant. There are limits on the right to sue and be sued to cater the factors such as the good relations with the different nations and foreign sovereigns and ambassadors and alignment with the one's own nation's foreign policy, alien enemy, facilitation of the efficiency in the preserving the law and order, municipality, state, central government, and justice and lunatic person. Now the question comes over there. Sir, there are so many cases are there now. How many cases we have to write it? I told you all. Cut your coat according to the cloth. If the marks are less, very few cases, or one or two cases. If the 15 marks are there, it is 3 to 4 cases you have to write it. But the time factor is very important factor because you cannot write the every case law there. Hence, when you want to write one of the case law, like I will show you the example here. See, Paul's graph case law is very important case law. What is the name of the case law? Paul's graph, Helen Paul's graph versus, see, this is the Helen Paul's graph versus the Long Island Railway Company. This is the case law. This case law actually says about the proximity. Number one. Number two, there is no duty on the part of the defendant. Number three, it's also the remote possibility would be there in this case law. But I will tell you the facts of the case law, don't worry. At any time it will stop it because now the 5 minutes are left over there. Nearly, of course, I will get the indication here. So if you happen to see the case law length is how much? See, I will show you. 16 pages length case law is there. It's only one case law I am speaking. Could you read the 16 pages case law totally? Of course, you want to get the mastery over there, yes, you can read it. But for their examination point of view, or from the student point of view, if you read it well and good, if you have such a patience. But if you don't have such a patience, At that instance, you have to read nutshell manner case law. See, this is given in the nutshell, only one page. Like pulse graph case law, if you happen to see the case law, I will see it, the pulse graph. First, you have to know it. You know the rails, railway track. I told you broad gauge, meter gauge, narrow gauge. Rails will be rest on where? Rails will be rest on where?
Junctions?
ఈ రైల్స్ దేని మీద ఆని ఉంటాయండి? రైలు పట్టాలు దేని మీద ఆని ఉంటాయి? దేనికి తగిలి ఉంటాయి?
Railway track?
Stones.
తింటా ఓన్ టాక్స్. ఈ రైల్ చూసారా అండి మీరు? ఇప్పుడు రైల్ లైన్స్ చూసారా?
Yes, sir.
ఇట్ విల్ రెస్ట్ వేర్? ఈ అడ్డంగా ఉన్నాయి చూడండి, ఈ అడ్డంగా ఉన్నాయి చూడండి. ఏంటి ఇవి? ఇక్కడ కనబడతాయి చూడండి. ఎర్లియర్ ఇట్ వాజ్ ద వుడ్ ఈజ్ దేర్, బట్ నౌ ఇట్ ఈస్ later on it was the iron was there, but now it is the concrete. దీన్ని ఏమంటారండి? ఇది ఈ అడ్డంగా ఉన్నాయి చూడండి, కాంక్రీట్ మధ్యలో ఇక్కడ ఫిక్స్ అయి ఉంటుంది. బోల్ట్స్, నట్స్, రింగ్స్ ఆర్ స్ప్రింగ్ ఆర్ స్కేల్స్ ఉంటాయి ఇక్కడ. వీటిని ఏమంటారు? ఇఫ్ యు నో ఇట్ యు టెల్ మీ. ఇఫ్ యు డోంట్ నో ఇట్ ఇస్ ఏ పాస్ ఆన్.
Pass on, sir.
Pass on.
3% అంటారు దీన్ని. ఏమనాలా దీన్ని? The rails will rest on the sleepers with what? Nut and bolt or a spring, and sometimes no, there would be some slit and here would be some slit, and here is one rod is there, a scale would be there which is ఒకవైపు ఏమో సన్నగా ఉంటుంది, ఒకవైపు మందంగా ఉంటుంది. So it will pass on. The railway man will try to beat it to fix it. The rail should be fixed to the sleeper. ఇక్కడ ఫిక్స్ చేసే దాన్ని కొడతారు చూడండి. ఇప్పుడు కొడతలేరు. ఇప్పుడు దేన్ని కొడతారు? స్ప్రింగ్ ని కొడతారు.
Fish plate.
ఆర్ యు ఫాలోయింగ్ మీ?
Yeah. Fish plate, sir.
ఇక్కడ ఫిష్ ప్లేట్స్ అంటారు దీన్ని. దాన్ని స్కేల్స్ కూడా అంటారు. ఇప్పుడు ఏమొచ్చినాయంటే, ఇప్పుడు నట్ అండ్ బోల్ట్ వచ్చినాయి నౌ డేస్, అండ్ దేర్ ఈస్ ఎ స్ప్రింగ్ ఈస్ దేర్ విచ్ ఈస్ ట్రై టు అటాచ్ టు ద రైల్ అండ్ టు ద స్లీపర్ విత్ a slit ఉంటుంది అక్కడ. సో నౌ the question comes over here. The two persons, those who want to enter into the train, two persons వాళ్ళు రన్నింగ్ ట్రైన్ వచ్చారు. They want, by the time that the train moved already, so they want to get in the train. So that is a fact. The claimant was standing on a station. Claimant అంటే plaintiff ఇక్కడ. The claimant ఎవరు? plaintiff Helen Palsgraf. She is a lady. She took the ticket and standing on the platform. అయితే 2 tracks ఉంటాయి ప్లాట్ఫామ్కి, 2 platforms ఉంటాయి. ఆర్ యు ఫాలోయింగ్ మీ? వన్ అదర్ సైడ్.
Yes, sir.
అదే దాన్ని ఏమంటారంటే, ఒకటి డౌన్ అండ్ అప్. డౌన్, ఇప్పుడు మన హైదరాబాద్కి పోయి మద్రాసుకు పోయినని డౌన్ ట్రైన్స్ అంటారు మనం. అప్ ట్రైన్స్ ఎప్పుడు? మద్రాసు నుండి న్యూఢిల్లీ పోయేటని, హైదరాబాద్ పోయని అప్ ట్రైన్స్ అంటాం మనం. సో ఫ్రమ్ డౌన్ ప్లాట్ఫామ్ ఈస్ దేర్ ఫర్ అప్ ప్లాట్ఫామ్, బట్ షీ స్టాండింగ్ ఆపోజిట్ టు ద ప్లాట్ఫామ్ వేర్ దిస్ ట్రైన్ హ్యాస్ రీచ్డ్. So the claimant was standing on the station platform purchasing a ticket. While she was doing so, a train stopped in the station and 2 men ran to catch the train. One of the men tripped and while another attempting to help the fallen man. Means the train moved over there, one fellow is got inside, another fellow could not get it inside, but 2 guards, one is in the compartment, one is on the platform. He pushed that the another person who could not able to get inside. The members of the railway staff caused the box of fireworks. He pushed it, another second man. But when the second man is pushing over there, he is having in the armpit. Armpit అంటే ఏంటిదండి?
ఇంకా
సంకానం అంటారు.